Welcome to the 2020 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple. This year's innovation was again held at the historic and elegant Vizcaya, not just in downtown Sacramento, but more on March 20th, 2020. Gemini Vizcaya prepared an exceptional morning assisting both the defense and applicant bar from Adobe Arcadia and John Pinto. The Adobe Road Financial Settlement provides notes of macro copying and subpoenaing services with hints of legal services, exam work, the Bevan provider of workers' compensation evaluations, blackberries and professional medical legal evaluators, and Ametro savings and support for injured workers. This year's conference was again held at the historic and elegant Vizcaya in downtown Sacramento on March 20th, 2020. Due to the COVID-19 outbreak and consistent with CDC protocols, this year's conference was limited to a live remote presentation and then simultaneous webcast from the elegant ballroom of the Vizcaya. The 2020 Current Issues Workers' Compensation Conference involved 4 separate panels and sessions of just over 1 hour and 30 minutes each and qualifies for 5.25 hours of CEB MCLE or QME educational credits. The first session will be Case Law Update with the focus on case decision originating with the WCAB. The emphasis for this year's conference is an historic review of the law of workers' compensation post SB 899 and SB 863. First session will begin with a review of various legal principles and doctrines with an emphasis on an historical review. The presenter will be Mr. Richard Montalbo, who will be presenting live from the ballroom of the Vizcaya. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. Mr. Montalbo is also the app developer and designer of the CompCalc, the industry's only smart device workers' compensation rating and indemnity app, as well as the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
Let me start by welcoming everyone, and as I look across this huge audience, everyone to the 25th Annual Current Issues Workers' Compensation Conference. You know, over the past 3 weeks especially, it's been particularly difficult. I'm going to be frank with you. I thought that we were going to cancel it at least on a half dozen occasions. 3 weeks ago, when people contacted me, I said, no, we've got this. We're still going to have a great 25th anniversary Current Issues Workers' Compensation Conference. I felt that because we were limiting our the number of active participants, that during our presentation that we were well within the initial CDC guidelines of 250. We expected to have between 150 and 175. Then they reduced that to 100 and we started scrambling, then down to 50 and ultimately down to 10. Currently we have a shelter in place. As all that was going on, I want to just walk everybody through, because today one of two things is going to happen. Either we're going to crash and burn, or we're going to be able to get this out hopefully acceptably well. Let me start by giving a tip of the cap to Sacramento Legal Video. Sean has been a partner of this with this conference for about 6 years now. And I know when I first made the decision to go ahead and webcast our conference, that a lot of people said, well, why are you giving away the content? And my thoughts were, all content in workers' compensation with regard to the law of workers' compensation in California is real stale. It's stale dated. And the content is current now, but it might not be current or as current 6 months or even 30 days from now. So my thoughts were, why not make it available throughout the state? And now in hindsight, it was lucky that we made that decision 6 years ago. Because today, and as far as I know, this is the first time this has been attempted, and I want to go through what we're going to try to attempt to do today. All but one of our speakers, myself and one other speaker, are going to be participating remotely. We tested 3 different platforms in putting this together. We tested the Facebook Live, we tested Zoom, and we tested Skype. And Sean made the decision that we go with Zoom, and it's because it has a number of automated features that are really going to hopefully look transparent to the end user, but will allow us to broadcast this up and down the state. Now, I want you to think about the logistics here. We have people remotely that are hooked up that are presenters. They're in shelter-in-place or under shelter-in-place orders right now. They will be broadcasting their signal into the Vizcaya. We are at the Vizcaya, although it's empty. Let me just comment on that. This is a elegant and beautiful facility, and it's really unfortunate that everybody's not here. We decided to come back to the Vizcaya because we were here for about 10 years during the first 8 or 10 years of the seminar, and we outgrew the size. But now, because we're able to broadcast it, it certainly provides sufficient size for our needs. But we're taking the signal from a remote presenter, sending it in to the Vizcaya. Sean of Sacramento Legal Video is going to take that signal, mix it along with the local signal, which will include a signal from the laptops so we can follow along electronically. That'll be posted on occasion up on the screen. And then all of that will be combined and sent out, almost as if we had a mini TV studio here, a production studio. So we're going to see how this works out. Bear with me if we have any problems throughout the day. I also want to thank, and this is a heartfelt thank you, the number of texts and emails and phone calls that I received over the last 2 weeks from the workers' comp community generally was overwhelming. And that's honestly, a lot of those is what caused me to sit down with Sean and all the presenters and test all the equipment and make sure that at least we had a fighting chance to pull this off today. I know that there's been, the DWC was way down in their number count last month at their conference. I also have heard that the CWCI, of course, I believe their conference was yesterday, had to be canceled or postponed. ExamWorks has been postponed. The California Applicants Attorneys Conference in Hawaii has been canceled, and they're looking at whether or not the San Diego Council conference is going to be postponed or canceled as well. So this may be the new norm, and certainly it's the best we can do, and we were lucky enough to have been prepared for this, although I don't think anybody could have imagined what's going on currently. I was contacted and asked to read over the internet, over our production, a en-banc decision and also the news that reflects the news line with regard to what's going on in the WCAB, and I think this is important. I'm just going to read it word for word so we don't, so there's no mistakes. This is a copy of the en-banc, I guess it's an order, or a decision, en-banc decision of the WCAB. And I'm going to start on paragraph 3. In light of the state emergency and pursuant to the authorities per WCAB Rule 100370, the Appeals Board is temporarily suspending specific rules, WCAB Rules of Practice and Procedure contained in Title 8 of the California Code of Regulations. This suspension is applicable to all district offices in the state and applies to the following rules. Number 1, dismissal of an application or lien claim for failure to appear is suspended. Number 2, WCJ and arbitrators shall have unlimited extension of time within which to issue reports in response to petitions for reconsideration or removal. Number 3, suspensions of the requirement in the compromise and release agreement for signatures from 2 witnesses. Signatures on forms from all parties may be electronic. And last, number 4, suspension of requirement for the service by the WCAB by mail. Service by the WCAB may be made electronically with or without the consent of the parties. And last, and they note the Newsline release, the WCAB DWC district office are currently closed for filing from March 17th through April 3rd. Now, there also is a newsletter that you should reference that came out this past week, and it outlines specifically with greater specificity what is happening at the WCABs. There was also an article that was penned by Mark Powell, and I believe this comes from the Work Comp Central, and it discusses their efforts to use telemedicine in the exam process for QMEs and some of the frustrations that they're having right now. Many of our doctors, and this is where I come down on this, I'm a pragmatist. You know, certainly I would say this about me. If you can say a lot of things about me, perhaps, but I would say this: I'd rather know the truth than have to be right. That's why everybody reads my materials and listens to what I have to say. I'm not a pragmatic, right, defense-oriented guy. I tell you what I believe the law to be, and over the last 25 years, I've been pretty accurate. I've taken a lot of heat over some of my analysis, but more often than not, it's been proved to be correct. I remember about 10 years ago when Alvarez Guzman came down in Ogilvie, all that was coming down. I took a lot of heat at my conference when I reported that, in my opinion, both were going to withstand the test of appellate review. In fact, one firm went up and down the state and said Montalbo's raising the white flag, and well, that case came down the way that I thought it was going to come down. When it comes to telemedicine, a lot of our doctors, our QMEs, even our treaters, but a lot of our doctors that are evaluating injured workers are, relatively speaking, in the high-risk group for an adverse reaction to COVID-19. And so I think that probably about it, I think the DWC ought to step up and say, listen, we need to make telemedicine part of the exam process, especially for those AMEs and QMEs that are in the high-risk group. And this article, if you take a look at it, will, I think, demonstrate some of the problems that are out there with getting the DWC to make those, acknowledge those changes. Okay. Let's talk about today's events and how I hope, I hope it's going to work out the way that we've kind of set it up. First of all, if you're logged in and watching this, I'm anticipating that the numbers are going to be pretty high. So this is, kudos to Sacramento Legal Video for putting this together. You have no idea how many flip-flops and processes and what we had to do to get to where we are broadcasting this. You should have by now downloaded the electronic materials. Just a couple of comments about the materials. You'll see them flashed up on your video screen throughout the course of today. One of the criticisms that I've had in the past on my written materials is, hey, Rich, we need more cites. We want to know why you're thinking what you're thinking and where it came from. Take a look at the case law update. I did two things this year to hopefully solve that problem. And I like criticism. I like to know what I'm doing right. We all do. I also like to know what I'm doing wrong. Nobody does, but we do. And here's what I've done this year. Two things. Number one, you're going to see with each case that I have companion sites, parallel sites, and you'll see a lot of but C, contra, but C also, and I reference other cases. You'll also see that after the case law section, right behind it, and I provided you with last year's case law update for completeness, and then also this year's case law update. But after that, you'll see that I provided you with all of my updates from last April of 2019 through to present, the update for my book, the Work Comp Index, a Topical Guide. LexisNexis is the publisher. Just a quick comment on that. Because we had so many reg changes this year, that book is slated for release. It's usually slated for release the first of the year, sometime in January, but this year we've had to hold it back, and it will be available as of June 1st. So, but what I've done is I've provided you with all those updated cases, an additional 6 months of cases that will be in the 2021 edition, the update. But those are available in your materials, so you can take a look at those. So number one, you should have by now downloaded the materials off our website. All registered attendees will receive MCLE specialization, QME certification. And I want to comment on that. I made one of the crazy things that I had to get accomplished this past week was to make sure the State Bar was going to honor our certification if we attempted to rebroadcast this, and whether or not QME certification. And it looks like right now everybody's going to honor that educational units. So I was pleased to get that affirmation. At the end of the day, and this is why everybody comes to the conference for really three things. We always have it in a really neat venue, but they come for what? Education, but that's a necessary evil, right? We're actually here for the great food. I can't help you with that. So go out to the kitchen, grab whatever you need to. They come for the wine tasting at the end. I can't help you with that. But we are giving away a number of really nice bottles, and they come for the drawing. So all the registered participants will be allowed to partake, will be eligible for the drawing at the end of the day, which will be kind of a neat way. You know, it's our attempt to make this as close to what we usually have as we can under the circumstances. Okay. The other reason that a lot of people come is to download the CompCalc, and I want to discuss a couple things that are going on with the CompCalc. For those of you that may be tuning in for the first time, the CompCalc is the smart device and computer and now internet full rating indemnity. It does PV, COLA calculations. Download it and take a look at it. But you can get it today for free if you have an iPhone or a Droid device for your iPad, iPhone, or Droid device, either at the Google Play or the App Store. Just simply type in my name on the search bar, the hourglass, excuse me, and it will come up with a couple of versions. Don't download the paid version. You don't need that. Download the Gemini duplication, the orange version of CompCalc, and that's a full functional version. A couple of years ago now, I partnered up with Gemini Duplication. They licensed the CompCalc for smart devices. So spread it around. It's honestly, I don't want to toot. Well, I guess I am if I say anything further, aren't I? It's a good rating tool. The other thing that I want to share with everyone is that this past year I was in discussions with the California applicants' attorneys. They wanted to select the CompCalc for their paid membership as their rating tool. And so what we did was we developed the AWS version, the Amazon Web Service version. That version has in fact, it has greater capabilities because we've added to that a TD calculator. Not only, we always had a TD indemnity chart that you could put in the average weekly wage, the date of injury, or you could, if you just put in the date of injury, it would give you the default, or you could merely bypass those and merely put in the TD rate, and then it would calculate it for you given a period. It acted as an indemnity chart to bring it up given the date of injury, giving you the max or mins, never above the max or mins given the date of injury. We modified that so that now on the AWS version you can also type in a string of incomes either on weekly, bi-monthly, or monthly basis for up to 52-week period to automatically calculate. And we have an export feature now that allows you, and this is important for claims examiners because I'm going somewhere with this, to print out that tape, calculate the average weekly wage based on that tape, based on the period, and then calculate the TD rate. And then if you put in a period of time for retroactive liability, it calculates the period of TD. You might ask, why did you do all that? Was it just for the applicant attorneys? No, because last month, before all this craziness, I was invited down to San Diego to do some educational training with AIG. Now, I'm one of the few attorneys on their panels that's a solo, AIG is currently, they put together a beta test group, and they're going to adopt the CompCalc statewide for their adjusters. So that's really a feather in my hat, because we're essentially a pretty small firm. Okay, so just to summarize, download the materials electronically from the website. You can install on your device free of charge the iOS for your iPhone, iPad, or the Droid version, the Java version for your Droid devices by going to the App Store or the Google Play. Okay, let's go through today's presenters and presentation. We're going to see how this is going to work. I know everybody's standing by, probably wants to see it's kind of like watching the potential for an accident, but that'll keep everybody involved today, okay? We're going to start out, I'll do a case law update. That'll be the next hour. And you've got the materials for that. I'm going to be followed by, and if there's any panel that I'd like to kibit on that I'm not probably going to be able to kibit on, it's the top cases of the past decade. And this is a really neat panel because there's a lot of great decisions that have come down, and the people that I've selected are two of the top people in the state, bar none. Joe Capurro, who is the president of the California Applicants Attorneys, a frequent speaker on the top cases panel for the California Applicants Attorney. I may overstate our relationship, but I think a good friend and good man. That's right, some defense attorneys actually like the other side, and maybe that may be detrimental to my practice, but so be it. He's a good man and certainly a legal scholar. He's going to be, and Joe's spoke and presented before. He's going to be joined by Ellen Lengal. Ellen is the general counsel for CWCI, for the California Workers' Compensation Institute. I've seen her present before. This past year, I approached her, I don't know, probably in September, October, and I said, what do you think? And she said, well, let me know, and we're going to have, anyway, it's a real coup to have her present at my conference this year, and I'm excited to see their take on some of the cases that are contained in the material. Now, this past year, we had a major decision, the Dynamex decision, and that was codified in AB 5. And so, of course, the issue is employee versus independent contractor. And so I knew, we discussed it at last year's panel, but I knew that we had to put a panel on this year because certainly that's a hot button issue. I'd say that and Halkitis, because we have this justice case that I'm going to touch on. But I'd say those two right now are the hot issues. And on that panel, I have Mike Giacchino. He's back with us. Of course, he's partner with H&B. He has presented in years past here, but he's a frequent lecturer up and down the state. He'll be joined by John Bloom. Now, this is John Bloom's first occasion to present at our conference. John is somebody who I've had to cross swords with over the years. He is a formidable applicants attorney in the Santa Rosa area. He's also on the education committee for the California Applicants Attorneys Association. The final panel, and these are going to go throughout the day, so all you have to do is look at the flyer to get the times. The final panel, I'm pretty excited to have somebody that I've known for my entire career of 35 years, and that's heading up this panel will be Dr. Frederick Newton. Dr. Newton, bar none, I don't think there's anybody in the state that will tell you that he's not the platinum evaluator and forensic evaluator in QME, AME. In fact, he only reports as an AME. The topic for the last panel, I should tell you that, is neurology and the medical legal process. Now, joining him is Mark Gearhart. Mark Gearhart is he's active member in CAW. He's a frequent presenter. He's done just about everything for CAW. In fact, he was single-handedly responsible for a lot of the education and the litigation involving Ogilvy. So he'll be on that panel. I know that he's also going to touch on Halkitis. So we have three panels that are really, I'm going to touch a little bit. We'll see if everybody agrees with what I have to say. Probably these presenters will not, because we all have our own ideas. Then they're going to touch on it in the top cases during the second panel of the top cases of the past decade. And then at the end, Mark has asked to address Hokkitis a little bit too. On that panel, we had planned to have Brian Egan. And Brian and I spoke Monday because understand, behind the scenes, nobody sees what we had to do. What we did was we set up these groups to monitor and test everybody's systems and make sure that we were going to have a good feed in and that we're capable of doing what we're trying to do. And he was all on board Monday. I haven't heard from him since Monday. So we've sent a number of emails, and he's a stand-up guy. I hope everything's good. I know that it is with Brian. Okay, that's the day's events. I'm going to sit down now, and I'm going to start my presentation. That's enough of long-winded nothingness. So let's go ahead and get started. The first topic that I want to address is not in your materials, and that has to do with equitable tolling and extending the statute of limitations. I'm just going to give you a couple of sites because what I anticipate happening is because our staff, and I'm coming at this from a defense perspective, but I don't think that it really matters. Because this virus may cause our staff to be out, we have to be armed with some arguments that allow us, if we blow through a filing period, to make an argument so that our claim or our defense is not barred by the statute of limitations. And I'm just going to give you a few sites here that I want you to take a look at. Government Code 8558B provides that a state of emergency, which has been declared, it has a full list, include epidemics. Now that has been declared by our governor. The cases that I want you to take a look at and the regs that I want you to take a look at are Lewis v. Superior Court, that's 175 Calap 3rd 366, 175 Calap 3rd 366. I want you also to take a look at Cal Code of Civil Procedure, Section 12A, and then 8, Cal Code of Regulations 10600 and 10605. We also have some panel decisions, and let me give you another site. And all I have is the ADJ number on this. It's Paul versus Department of Forestry. It's a 2019 decision, ADJ, and this is cited in the decision of the recon unit, ADJ 9159725. That's 9159725, and then 7757931. Take a look at that, and it'll provide you with, I think, some direction on if you have an oops moment under these under this scenario, what you might have available to you by way of legal arguments. Another topic that I want to discuss that's not in your materials is the standard of proof that may be required. 2 weeks ago, a large carrier that I represent invited me to attend a phone conference, and the issue was, what if any impact is the COVID-19 going to have on the workers' compensation industry generally, and in particular liability, and what are we going to do to defend these cases? And I'm not sure that they really liked what I had to say. But here again, I've told you, I'd rather know the truth than have to be right. I don't, at this point in my career, I don't have to do anything but tell you the truth. And I think it's best demonstrated. I'm going to give you some sites on this. Now, this is not an issue as to whether or not somebody has a diagnosed condition, because there's an objective basis for determining whether or not somebody has COVID-19. The issue is whether or not it's the result of an injurious exposure event or activity that caused that exposure and that illness. And I want you to take a look at this case. I reported on this back in 2007. No, it was 2008. And it's an interesting case, and I think it applies here. before I get to this case, I want to go through historically how this area of the law has developed. It started out originally with Hep C cases back in the 80s. Then we had HIV cases in the 80s and 90s. More recently, we've had some decisions involving valley fever and Lyme disease. And the issue has always been, well, the diagnosis is objectively verifiable. The issue is whether or not it's industrially caused. And we have three standards that possibly could be argued. Number one, is it reasonably medically possible? Is it reasonably medically probable? Is it reasonably medically certain? Those are the three standards that all these decisions have involved. The case that I want to discuss briefly, and I'll give you a couple of other sites, is the City of Turlock versus WCAB 2007. This can be found at 35 CWCR 208. That's 35 CWCR 208, as well as 72 CCC 931. What happened here is we had applicant had worked at in the city sewer department system for over 16 years. Now, during that period, he testified that he had on repeated events been exposed to raw sewage. He also testified that at least on one or more occasions, he had breaks in his skin, and that those breaks in his skin certainly came in contact with raw sewage. In fact, he testified that he had skinned his leg on one occasion that he remembered, and that had come in contact with raw sewage. Ultimately, of course, he contracted hepatitis C, and he filed it as an industrial injury. Now, what happened in this case was the defendant sought to establish, and was not able to, that there were risk factors such as intravenous drug use, homosexual activities, or blood transfusions. None of those had existed. Ultimately, the QME indicated that based on his opinion, that he felt that it was reasonably medically probable that that was an industrial caused illness. It went up, and on review, the 5th District Court of Appeal wrote that medical probability, not medical certainty, was the standard, and that without an alternative explanation as to the cause of the applicant's contracting Hep C, the industrial exposure satisfied the medical probability standard. Now, I want to give you two other sites, and I want you to take a look at these. These are in accord. We have a 3rd District Court of Appeal case, the Rosa versus WCAB. That can be found at 16 Calap 4th, 1692, or 58 CalComp cases 313. We also have the McAllister versus WCAB case, and that's a 1968 case. So you can see how it's gone forward. The case that I just described, the Turlock case, City of Turlock, was 2007. The McAllister case, which can be found at 69 Cal 2nd 408, 69 Cal 2nd 408, that's a 1968 decision. Then we have the Rosa case. That's a 1993 decision. And then, of course, everything seems to go back to Bethlehem Steel. And that can be found at 21 Cal 2nd 742. And that's a 1943 decision. So what was my analysis? What did I tell my clients? This is what I concluded. And the defense bar is not going to like what I have to say right now, but I would challenge everybody to tell me that they believe it's otherwise. On the defense side, we're going to have to establish that the exposure was non-industrial to avoid the COVID-19 claims. I have one client that called me up, another client, and said, we just got 16 COVID-19 claims. And I said, 16 in one day? What is that about? And they said, it was safety officers. One of them transported, or a group of 3 transported from the airport or from their home, somebody who was sick, turned out later to be COVID-19 positive, and the entire station filed on I guess a quasi-prophylactic basis, filed those claims. And they also wanted my thoughts, and I told them what I'm about to tell you. The only way to avoid this liability, and it's going to be even more difficult as the spread increases, is to establish that the only viable exposure the medically probable exposure was non-industrial. And just think about the difficulty there. What I told my clients is, anytime the person who's COVID-19 positive has a general interaction with the public generally, and/or has a co-employee who is positive, I think it's going to be very difficult to avoid that liability. Now, you might say, Richard, most people get over this, or it appears that most people get over this. They do. But the problem is, the ones that don't, the medical treatment alone can be catastrophic. There may not be a lot of PD, but I can see some death claims, and I can also see significant liability for medical treatment. Okay, that's all I have to say about that, except I was supposed to tell you this. If you have a question or comment, all you have to do is send an email, and we have somebody monitoring those emails. I just looked over at my office manager, Tori, and she, I was wondering why she wanted me to announce this and what was up, and this is what she's shaking her head. All you have to do is email us at office@montarbolaw.com with your questions, and I'll be taking a look at those at the breaks and also at lunch. And to the extent that there's one of the things that I like when I present is the audience, I always ask for comments and questions. I'm not somebody who just gets up and reads something. I want to be challenged, because guess what? This is just one man's opinion. Okay, let's go ahead and get started with the prepared case law materials. I want to start this by going through with you what I believe are the three pillars. And I want to go through this because every time, more often than not, whenever somebody misunderstands a case, I think it's because they wanted to say something it doesn't say. And they're not applying these three doctrines that are really pillars in the workers' compensation, And those three pillars are the doctrine of substantial evidence, the doctrine of direct causation with respect to PD, and burden of proof. And what happens so often is a case that can be explained through application of these three doctrines is twisted so that the applicant or the defense bar can make an argument that to their best, in their favor. To their greater interest. And that's just wrong. What I have to do in my job with the book is to cut out the shaft from the wheat. And I have to decide, is this what this case really stands for, or is this a misinterpretation? Let me give you the best example of that. Back in 2007 or 8, we had a case that came down. It might have been 2006. We had a case that came down, the Steinkamp decision. And I was presenting at the California Applicants Attorneys Conference on apportionment. And of course, we had by then Escobedo, and we had a number of cases that were coming down, and I was asked, at that point in time, the applicant attorneys, the common sense, or the main thought was that, hey, guess what? We have this Steinkamp decision, and this is great for us. Now, let me tell you what Steinkamp was, just basically. I haven't reviewed it in a number of years, but it was a decision that said that you can't, this is what the applicant attorneys believed that it stood for. You can't have apportionment if you remove the pathology, and it was a total knee replacement surgery. And so what the applicant's bar was saying was, hold it. If there's no pathology, if the defendants can apportion to asymptomatic pathology and we remove the pathology, gotcha. And what I said, and there was a little bit of a riot, I went, no, that's too strong. There was certainly some controversy during the discussion. And I remember Mark Marcus was on the panel and Mark Gerhardt was on the panel. And the point that I was making is, no, this is a substantial evidence case. The doctor didn't do it right. He didn't connect the dots. He didn't explain the how and why. If he had said the applicant had pathology that was 50% non-industrial, 50% industrial, it became so symptomatic that that pathology was so painful that they had to do a total knee replacement surgery, that total knee replacement surgery resulted in the present level of disability, which would not have been present but for the non-industrial pathology. In other words, connecting the dots up through the surgery and leading that directly into the whole person impairment and or resulting disability. And anybody that's heard me speak has heard me explain why it should be whole person impairment and or resulting disability on the analysis. But what I said was, it was a how and why case. The doctor just didn't meet the standard. Well, they didn't like that at all. Query, and I'll be discussing this in a few minutes, what Halkitis does to that whole analysis. And I've got some, what I think is going to be the Halkitis doctrine in the future. Okay, so let's go through these three doctrines. Number one, substantial evidence. What's required for substantial evidence? That requires that there be evidence in workers' comp, either medical or factual, that the doctor relies on, or the WCJ and their FNA relies on, in reaching their opinion. In other words, it has to be supported. It's the analysis in IRAC, it's the how and why, it's connect the dots. That's what substantial evidence requires, okay? What is the doctrine of burden of proof? And I want you to think as I go through this, how some of these cases can be explained. What's the burden of proof? Well, the burden of proof is pretty simple. You have to know two things. Number one, what's the standard and who has it, okay? And understand it can shift back and forth. So what's the standard? The standard for burden of proof, the general standard is what? Preponderance of the evidence, more likely than not, okay? The second aspect of it is who has it. And this is what I tell my law school students. Who has the burden of proof? It's the party. This is a simple definition. It works every time, ladies and gentlemen. The party who benefits from the affirmative on the issue. The party that benefits from the affirmative of the issue. So who has the burden of proof on AOE-COE? Well, initially it's always going to be the applicant. Who has the burden of proof on apportionment? Well, it's going to be the defendant. It may shift back and forth and there may be different aspects of it, but the initial burden of proof is always determined. Some of these cases can be explained by either party not doing their job and establishing the burden, meeting the burden of proof. Now let's talk about direct causation. This is the third pillar, and this only applies to disability, permanent disability. Direct causation is simply stated as this, that the employer is only liable for that portion of the disability. I say whole person impairment and or resulting disability, but we only apportion disability, but how you get there is why I say and I'm not going to get into that today. But the employer, the defendant's only liable for that portion of the disability that is directly causally, and I say, we haven't seen this in any decisions yet, exclusively resulting from or caused by the subject injurious industrial event, activity, or exposure, the industrial injury. Okay, that's all the employer is going to be liable for. Okay, the first area of cases that I want to discuss are apportionment. And I want to give you my overview on the law of apportionment, because this is the only place during today's presentation that anybody's going to give you an overview and analysis of the law of apportionment. And this is how I think about it. There's really four things that you have to think about when you talk about apportionment. Number one, who has the burden of proof? And I've already indicated in the old Pullman-Kellogg case, we know who has the burden of proof. It is the defendant. Number two, what type of apportionment are you going after? Are you going after apportionment to causation, which is 4663, Labor Code Section 4663, or apportionment to a prior award? And last, what are the elements of establishing either of those? Okay, let's go through real quickly apportionment to causation. Number one, every time I read a medical report, I'm going down this checklist. What is my checklist? Number one, is it that opinion on apportionment is based on full, complete, accurate medical history with a proper diagnosis? Those are the elements. Number one, full, complete, accurate medical history with a proper diagnosis. Obviously, if it's an incomplete medical history or incorrect diagnosis, well, that opinion cannot constitute substantial evidence. Number two, it has to be based upon reasonable medical probability based on the doctor's education, training, and experience and understanding the facts involved in the case or presented to him by way of a hypothetical. Let's break that down. It has to be based on reasonable medical probability based on the doctor's education, training, and experience. In other words, what that means is you can't have a psychiatrist commenting on orthopedic surgery. You can't have an orthopedic surgeon commenting on internal medicine. It has to be within their field of expertise. And it has to be based on their understanding of the facts, because if their understanding is wrong, guess what? It's not going to constitute substantial evidence, or facts presented to them by way of a hypothetical. And last, and here's where most of the litigation is, that opinion has got to connect the dots. It has to provide the how and why. It has to provide the analysis. The doctor says, I see this fact, I see this diagnostic study, I see this evidence of injury, and I'm applying those facts to establish my opinion regarding apportionment. Okay, so that's apportionment to causation. Let's talk about real briefly, and I need to speed up, apportionment to prior award. That has 3 elements. And I've said this all along, and you're going to see that in the Hahn case that, once again, they validated what I've said for years. Those elements are the following. Number 1, you have to have a prior award. Remember the old Pasquato case where they tried to apportion to a compromise and release? It has to be a prior award, either by way of F&A or STIP. Number 2, it has to be I used to say, it has to be on the same side of the fence. And what I meant by that is, it used to be relevant, they both have to be under the AMA guides, or they have to be under the old guidelines. Now, the Hahn case tells us, guess what? It also has to be the same type of rating, okay? So that's what I mean by the same type of the fence. You have to be apportioning apples from apples, not oranges from bananas, okay? And number 3, overlap. And generally what the cases tell us in overlap is that it has to be the same part of body, or at least same region of body, okay? You have to establish that there's overlap between the prior award of PD and the subsequent. Now, which of these 3 do we see the least of? I see apportionment to a prior award being the more difficult. Why? Because we can have a doctor apportion to causation and never even touch the fact that there's a prior award. He looks at the medical evidence dealing with the prior award, and then he gives us percentages to establish that level of apportionment. Okay, let's talk about the Hahn case. First decision, Hahn versus City of County of, let me get there real quick on this. The Hahn case involved a date of injury, successive dates of injury of occurring on 7/29/12 and 11/16/13. The first date of injury was STIP'd. It was based on a DRE 3, 20%. The second date of injury was rated out at 14%, but it was an ROM. And the issue was, is the defendant going to be entitled to apportionment? And I want to read what the court held. First, the WCJ held for the applicant holding a defendant did not meet their, burden of proof in establishing one of the critical elements overlap as a different metrics or standard was used. On reconsideration, the WCAB upheld the WCJ holding apportionment to a prior award pursuant to Labor Code Section 4664 requires that the defendant prove overlap between the current and prior award of disability, and where different AMA methods are used, in this case DRE versus ROM, defendant failed to meet that burden of proof. So that says what I have said all along. You can see in the box on that I went ahead and highlighted, lifted right out of the decision what I thought was the most important part. Okay, let's talk about Estrada. We can't talk about Estrada without first talking about Halkitis, because Estrada is a further discussion of the Halkitis principle. And now on this, I think there's going to be some applicant attorneys that probably take issue with what I'm about to say. And we're going to see. I want you to think about over the years how many times I've called it correctly, and it's all been documented through my writings. This is what I think, and we'll see. I could be next year telling everybody, well, I blew that one. Halkitis, you'll recall, was whether or not the defendant was entitled to apportionment. I'm going to torture the facts, but I'm going to give you rough justice on the facts. It was a bilateral carpal tunnel. The applicant, the doctor found 10 or 20% apportionment to non-industrial causation. The applicant underwent surgery, and post-surgery, I want to say that again, post-surgery, the applicant developed complex regional pain syndrome. Okay? There was no evidence in the record of pre-existing complex regional pain syndrome, none whatsoever. The doctor said that because of the development of complex regional pain syndrome, the applicant was 100% disabled, and of course the defendant wanted apportionment to the non-industrial causation. Now, what's the difference between that? And this is what I say about Halkitis. It is application of the principle of direct causation. Halkitis is wrong, and there's been several decisions that have been wrong because they say that where the disability is resulting from a surgery, there is no valid basis for apportionment. That is wrong. We have decision after decision after decision, pre and post, that say we're apportioning. Why? Because it's not a different condition. It's the same condition for which the treatment was being provided. Where you have, and this was my analysis 2 years ago when I discussed Halkitis, where you have an Halkitis situation, it is a new diagnosis. It is something that was not present prior to the industrial treatment. It arises out of that treatment. Some people have said it's a new injury. I don't agree with that. I think that it is essentially a new condition for which there's only one explanation, not the original industrial injury, but the subsequent industrial treatment. And in that situation, I do not believe the defendant is entitled to apportionment. So that's limited. I've also said that you'll note that a lot of these cases dealing with, because once again, we have to work in these three pillars, these three doctrines, the doctrine of substantial evidence. Remember, Halkitis involved what? An AME. I think that that's an important fact as well. Let's talk about Estrada, and let's see how that dovetails. Estrada, the applicant had an injury to back that resulted in surgery. As a result of that surgery, the applicant had some complications, including severe deep vein thrombosis. Okay? The issue was, now, ironically, we'll be able this afternoon to ask Dr. Newton because he was the AME in this case. He apportioned 1/3 of the back PD to non-industrial causation. But the internal medicine doctor indicated that the applicant was totally disabled and that it was the deep vein thrombosis that resulted from inactivity and the surgery, post-surgery inactivity and the surgery, that really rendered the applicant 100% disabled. The court held, and I want to read this real quick because this is important. This is the testimony of the internist. The question is, but none of those pre-existing conditions in her inability to work is solely the industrial injury. Answer, yes, that's true. Question, you still believe, after everything you've heard here today, that just diagnosis 1 and 2, and that's referring to the deep vein thrombosis and that portion of the back, 1 and 2 alone, her back injury, her back surgery, and the deep vein thrombosis are sufficient, those 3 alone, are sufficient to make her not employable? The answer is, well, that's what I said, that's what I told her, yes. Okay? So therein lies the point. We have a different diagnosis, a different condition that arises out of medical treatment that I believe is going to be determined to be the, through application of direct causation, going to be the limitation on Halkitis. I think that the defendant's still going to be entitled, just like in the Steinkamp decision. If it's the same part of body, same condition for which the surgery is being provided, I don't believe, and this is my phrase, I don't believe a surgery is going to sanitize, that's important in these days, sanitize all basis for apportionment. It may, where there's a new condition that arises out of it, a new diagnosis. But to say, go get a surgery, can you imagine this? The applicant attorneys say to their client, go get a surgery because it's going to sanitize all your pre-existing apportionment. There'll be no basis for it. I don't think anybody listening to me is going to find that to be a valid response. Now, there's another case dealing with Halkitis that I put in here. I'm going to let you read it because you know what? It's graphic. I don't really even want to go through it. It's Chadbourne. This was a psychiatric injury arising out of medical treatment because the doctor was a bad man. Okay? And you can read that on your own. Now, I have a couple of SIGA cases. The only one that I want to touch on is the Azar case because it stands for the proposition, as we've all felt for a number of years now, that Medicare was not entitled to reimbursement from SIGA. You know my mantra when it comes to SIGA, I was going to be graphic, but they always win. So that seems to be the way it works with SIGA often. Okay, let's go to the the Lasco case. And the reason that this is important is because it's a little bit scary for defendants. I want all defense attorneys to listen to this. Let me give you the facts on this. There was an injury to various parts of the body, part of which were contested, part of which were not. The defendant, who was elected against, did what all of us have done. He settled it by way of compromise and release, but he left open, and I want to discuss when this is applicable, he left open future medical care. And an open med CNR is what we call it. A lot of people will not do that. This is what I advise my client. It's not inappropriate to do an open med CNR unless you're paying for the future med. In other words, if you're only paying for the PD and the right to reopen, what do you have? You're extinguishing the right to reopen, and you're resolving the PD and TD. You're just leaving open the future medical care. If you stip it, they still potentially have the right to reopen, and they still potentially have, as part of that, additional periods of TD that up to 104 weeks if they weren't paid. So if you're not paying more than that, there's no reason that I can see not to do an open med CNR. With that caveat, and I have clients on both sides of this, some will do it, some will never do it. But the defendant in the Lasco case went ahead and did an open med CNR. When he did the open med CNR, he was contesting whether or not I believe it was internal, it was internal conditions, including constipation, high blood pressure, and GERDs, and that sort of thing, whether or not those were industrial. But in the open med CNR, he included those as industrial. Now, a better open med CNR would have been to settle everything and accept out for future medical care the parts of the body that you accepted. He did not do that. He went off to arbitration. The arbitrator went ahead and said, listen, there is not sufficient substantial evidence to demonstrate that these contested parts of body were caused by the industrial injury as alleged. And the arbitrator issued a decision saying, listen, you're entitled to reimbursement, contribution. I think this was a single CT, so it would be contribution. But it's only as against the part of body that you've established were industrially injured. You're on your own with the other parts of body. That was upheld. So what do we take away from that? As defense attorneys, we want to be very careful. Number one, we should always be careful about open med CNRs in limited circumstances. And number two, if we're going to go after a co-defendant, we want to make sure that when we accept that claim, it's not a good faith belief that there's liability there, but that if we go to arbitration, that we can establish that liability. Okay? Let's talk about the Franco decision. I'm not sure that the Franco decision has a major impact on Laura. I know that I listened to the commissioners at the California Applicants Attorneys. They seem to indicate that they believe that it goes further than it does. I'm not going to take a lot of this is a 132A case in which, and I'll just give you the basic facts. The facts are not good for the defendant. Can I just make a comment here? The worst cases for the defendant, the worst cases for the applicant are where they take them up and the facts are bad for making bad law. This made bad law. Why? Because there were critical facts in this that the employer really wanted to sever the relationship with this applicant. And I can understand why that was, because the applicant was a bus driver, had minimal residuals. The level of disability was a 1 in 3%. It wasn't a lot of disability, and yet the applicant was complaining that he needed modifications. Then he went back to work full duty and worked for 4 or 5 months, and then they ultimately terminated him. They separated him. So those are bad facts for the defendant. Now, what should they have done? And this is the teaching moment on this. Whenever defendants want to increase the likelihood of separation with an employee and they want to avoid a 132A, they should be very careful, very careful. And I caution my clients about that. But if that's the direction that you want to take, you want to, number one, engage in the interactive process. And I do this frequently for my clients, and there are 3 aspects. We sit down face-to-face, number one. We're face-to-face. Counsel for applicant, the applicant, myself, and the employer. What are we going to do? The first thing that when I direct one of these meetings, is I go over the essential job functions, job duties. I want to make sure that everybody's on the same page as what's required. Second, we review medical records and we go over the work restrictions. Number 3, we decide whether or not accommodations are necessary if the applicant can return to full duty. And if accommodations are necessary, The employer has got to accommodate in California. FEHA requires that, 132As require that. You've got to make those reasonable accommodations. The larger the employer, the greater the accommodations. It's just that simple. Now, one of the things that you can do is you can do a settlement by way of compromise and release. And we have a reg that came down this past year that I'm not interpreting the way some people are, and I'll be going over that in just a moment, that prohibits an employer from refusing to rehire. But it doesn't prohibit a voluntary resignation. And that's what I think the separation is on the new reg. So if you were to, let's say, increase, and I have clients that are all on board on this, they would rather pay a higher amount for settlement by way of compromise and release to include a voluntary resignation and separate. And often applicants would rather have that as well. And that's a win-win. But what I want to stress in discussing this case is the interactive process should always be engaged in any time you're about to separate an employee. To do so otherwise is crazy. Okay, I'm just going to touch on the Robles case. I'm going to speed this up real quickly. I had a case a year and a half ago where the applicant asserted her Fifth Amendment right to self-incrimination. Why? Because she was submitting to two different carriers. We didn't know about each other. Mileage reimbursement, and my office manager is smiling right now. Mileage reimbursement to both carriers. She was then getting paid from both carriers, and she did this for 2.5, 3 years. And then when we caught on to it, I set her deposition. She immediately sent a check to my client for, and I'm going to put this out there, but I don't know the exact number. It was like $4,736.58. Now, how do you get that down to the penny unless you know exactly what you're doing? I go to the deposition. She had a retired judge from Southern California. I'd like to say he was a wonderful person, but he was wrong in the law, and he was wrong in how he handled the case, I felt. I showed up and I attempted to resolve the case because I am not, let me say this, ladies and gentlemen, I'm not a kitty cop. I'm not your mommy, I'm not your daddy, I'm not your sheriff, I'm not DA. What I am is I close files. And so I showed up and I made a very reasonable offer. Both the co-defendant and myself made a very reasonable offer, a large amount, but we wanted a voluntary res. He turned around with that and he went to the board and said that I was engaging in unethical behavior. He also refused to, so it was anyway, I think every attorney would be upset with that. He didn't go far. The judges who all know me said, listen, sir, and that's the way it went down. But here was the issue. Later, his client would not answer any questions and asserted the Fifth Amendment, and yet I couldn't advise my client not to provide benefits because we kept scheduling, he kept promising, and it just kept going forward. In the end, I got an order compelling. And when the writing was on the wall, the case resolved. So just be aware of that. That is the holding here. You can assert the Fifth Amendment. We can't compel you to testify, but it can be used against you in establishing any of the issues that you have the affirmative on. Let's skip ahead a little bit. I have a case on a disqualification and reassignment of judges. My comment on judges are this. By and large, they're all exceptional. There's very few instances where I've thought that a judge was subject to any type of a ethical violation, and certainly they study hard and they're very competent, and that's been my experience. And if you're having an experience otherwise, I think you really need to buy a mirror, perhaps. I'm going to pass the Forever 21 case, and we're going to go ahead, and I want to go to Carrasco. This is the presumption case, and this is on page 8 of your materials, and I think that we're close approaching where I'm going to end. In the Carrasco case, this is on page 8, the claim was not timely denied. So it was presumed compensable under 5402. But there was a compensable consequence, psychiatric injury, and the issue was whether or not it was barred by good faith personnel action. And the issue became one of whether or not the defendant could come forward and present evidence on an affirmative defense. The holding in that case was that they could. and they allowed that to occur. I want to touch a little bit on page 9 on the Allen case, because there are a lot of people, I think, misinterpreting the professional cases. I hear from the applicant attorneys that the attempt here is to do away with cumulative trauma injuries. I'm in total disagreement with that. I think the confusion on these professional athlete cases have to do with what area of the law each case discusses. So this is how I organize it, and I think if you do this, you'll understand it. Are they discussing in personam jurisdiction, subject matter jurisdiction, or conflicts of law? And what is the law that applies? And if you use those three, what are they really addressing here? You're going to be able to characterize those decisions correctly and understand them correctly. What happened in the Allen decision? Well, he had 3 contracts. The contracts were entered into, 2 were entered into within California. The last one was not. Applicant played only 1 game in California, and the defendant sought to be dismissed. The judge allowed that dismissal. Now, this was an issue on whether or not there was in personam jurisdiction over this defendant. And what the judge said was, well, hold it. You know, he didn't sign the last contract in California. He only played 1 game. That's not sufficient minimum contacts within the forum state to bring jurisdiction in personam. Wrong. Wrong. It's not whether or not the applicant has sufficient minimum contacts within the forum state. It's whether or not the defendant has sufficient minimum contacts so that the defendant does not have, if he has to come in and defend, is not denied due process. That's in personam jurisdiction. Sufficient minimum contacts on the part of the defendant, not the applicant. You can look to the applicant for factors. If they had meetings and the applicant was there, certainly. But it's based upon the analysis of we don't want to deny due process, the due process requirements on the part of the defendant within the forum state. Now, I want to read this box here, because in this box is succinctly put what I think is a valid, real brief statement. You know, that's my forte. When I teach, I try to break everything down to its basic common denominator. And because I flew in the Navy and because I write code, I'm always A plus B equals C. That's how my mind works. So let me read this box. Simply stated, for the WCAB to have personal jurisdiction in personam, there must be sufficient minimum contacts on the part of the defendant within the forum state, California. In establishing an in personam jurisdiction, the courts have traditionally considered factors to include where the contract for hire was negotiated and executed, where services were to be performed, defendants' business dealings within the forum state, and where the parties were domiciled, residing, focusing on whether requiring an out-of-state defendant to defend in California would be so unfair as to cause a denial of due process. Often confused is the distinction between in personam jurisdiction, subject matter jurisdiction, and the issue of conflicts of law. Simply stated, in personam jurisdiction focuses on whether Simply stated, in personam jurisdiction focuses on whether the defendant has sufficient minimum contacts within the forum state to ensure due process. Subject matter jurisdiction is merely whether the particular court is proper, given the issue at controversy, and focusing on the doctrine of forum nonconvenience, while conflicts of law, choice of law, is generally always the law of the forum state unless modified by contracts between the parties. That's a general application of the law in this. And if you read all these cases, you realize, hey, guess what? Nobody's taken away cumulative trauma as a claim of injury. What they're doing is they're saying, you're at the wrong place, or this is the right place. Okay? Okay. The Hollingsworth case, this is on page 10. I just want to note that what happened here was you had a civil and you had a workers' comp, and there was an issue of exclusive jurisdiction. And the court first to assume jurisdiction was the court that had jurisdiction over the issue. Okay, let's go to page 11. I just want to run through this, and I think this is probably going to be the end of my presentation. First of all, I have a list of the regs that I think are important that have changed, and I'm just going to touch on these. Of course, Labor Code Section 2750.3 was enacted to codify the holding in Dynamex and the ABC test. One of the big changes for us who represent safety officers is Labor Code Section 3212.15. This is another presumption for safety officers of PTSD. I'll be frank with you, that is the most difficult. Next year, we're going to have a panel, I've decided this, on presumption. All the different presumptions and how virtually the only way, here's a general rule, the only way the defendant wins on a presumption is to clearly and absolutely establish that the condition, the injury, the pathology was not caused by the applicant's, could not have been caused by the applicant's employment as a safety officer. SB 537 also modified 4600.4, and this is, we have a case discussing this, but defining normal business days. We've got SB 537 amended Labor Code Section 4616A4. It requires that the NPM websites be updated quarterly. And then some of the top rule changes. Let me also tell you, I put in the box this CCP 1002.5, and I want to read this. This is, it's captioned, Agreement Settling Employment Disputes, Prohibition of Preventing a Person from Obtaining Future Employment. B reads, nothing in this subdivision A, everybody reads A, nobody reads B. Nothing in this subdivision A does any of the following. Number one, precludes the employer and the aggrieved person from making an agreement to do either of the following and a current employment relationship. I don't think it can be any clearer than that. Okay, top rule changes. Let's go through this really quick. Lien claimants under 103.05 are now deemed expressly parties, and that has implications for service and involvement in hearings. 10.403 10.404 permits disciplinary action on hearing reps, and you know, about a third of my practice is in Southern California, and some of the, and I don't want to be over the top here, but some of the behavior of the lien claim representatives is difficult to understand, and I know the judges have felt that way on occasion as well. 10.620, all documents which a party seeks to offer at trial must be filed with the WCAB 20 days prior to trial unless otherwise ordered. Now, I do not interpret this as requiring filing 20 days prior to an expedited hearing, which arguably is a trial. And the reason for that is the expedited hearings are set within 30, often within 20 days. Does that mean that if the applicant files a DOR for expedited hearing with their exhibits, that we're precluded from introducing any exhibits? So, but I do believe that it applies to our standard trial. Now, what I generally do is I serve all my exhibits when I prepare for my MSC. There are some exceptions. There may be some things that I want to hold back, but generally I handle my MSCs as an opportunity to tell or inform opposition why they ought to settle. But I want to, unless otherwise ordered. And so what I see the judges already doing is ordering on the minutes of hearing that the parties are to serve and giving direction on the service of those. There's a provision regarding 5710 fees. I'll be frank with you, it's going to have a de minimis impact on my practice. In 35 years, I've never litigated a 5710 fee, and generally, in Northern California, more than Southern California, those issues are worked out. There's just not enough money for a smart defense attorney to go and fight a 5710 fee with or without proper filing in a petition. There's also a requirement now for a petition for seeking TD overpayment. Well, I think that would be the case anyway if you're going to set that as an issue for hearing. You want to tell everybody, but certainly when you're negotiating it and taking an offset, I don't believe that requires that a petition be filed if it's resolved between the parties informally. Let me take a look and see if there's anything else, because I am at my time. This is what I would challenge everybody to do. You'll see that I have a lot of companion sites and cross-references in this. Take the time. If it were me and I was attending this conference, this is what I would do. I would go ahead and take a weekend. I would sit through everything that you're going to hear, all the analysis from some of the top attorneys in the state who are presenting here, and then take a weekend, 2 days. And I would read every case in the case law update and all the additions to my book, and then maybe review some of those online if a decision sparks your interest. And you're going to be pretty much up to date. Then the next most important issue has got to be the top 10 cases, or the top cases of the past decade, rather. That will give you a real overview of the law as it currently exists. And then I would also want to really focus on the impact that the codification of AB5 and the modification or codification of Dynamex is going to have on my practice, both on the applicant and defense side. Okay, I'm going to adjourn my presentation at this point. We're going to take about a 15-minute break. We'll reconvene, and we're going to see if we're going to crash and burn, or get this off with a remote access for the remaining presenters. Okay, thanks so much.